Good morning, all of you. So today I'm going to start the last chapter of your history civics portion. That is the Supreme Court. Okay, that is chapter number 4. So all of you open your book, page number 200. Open chapter number 4. That is the Supreme Court. So before starting the Supreme Court, let me first give you that we are going to study the third section of your civics. That is the judiciary. Now, you know that the government has three organs: legislative, executive and judiciary. Okay, we are going to study about the third organ of the government, that is the judiciary. Okay, now what do you know about judiciary? You need to understand this, that our constitution, under our constitution, the judiciary is a single integrated system. How will you define our judiciary? Our judiciary has a system which is called single integrated system. Now, what do you mean by single integrated system? Single integrated system is the system where Supreme Court is the apex court. Apex means the highest court, the head court. Who is the head court? Supreme Court. And the lower court follows the rules, regulations and instructions of the Supreme Court. First thing. Second thing is that all the court follows the same set of law. It's not so that the law followed in the district court is different from the high court, or the law followed in the high court is different from the Supreme Court. ऐसा नहीं है. All the three courts followed the set of law, same set of law. Okay. The third one, our constitution has given this authority that all cases can be filed if the person is not satisfied with the judgment of the lower court, can appeal to the higher court. Like district court is there, if the person is not satisfied with the judgment of the district court, can appeal to the high court. If the person is not satisfied with the judgment of the High Court, can appeal to the Supreme Court. But if the verdict is given by the Supreme Court, then that is the final verdict. It cannot be changed. So the judiciary organ of our constitution, under our constitution, the judiciary is a single integrated system. So how will you define the judiciary of India? Single integrated system. And what do you mean by single integrated system? First, Supreme Court is the head of all the bank. Second, all the court. Then, all the court follows the same set of law. Third, all the cases coming to the lower court can be filed in the higher court. Okay, so our judiciary has a single integrated system. But this is not in your syllabus. If you see the chapter 4, we start with the judiciary. This I have explained you so that you will be able to understand. In your syllabus, only Supreme Court is there. We will not study about High Court or District Court because that is not in your syllabus. So we'll start with the Supreme Court. Okay, and we'll start with the first topic of the Supreme Court, which is given in page number 200. That is composition, means the number of judges in the Supreme Court. So the Supreme Court of India consists of one Chief Justice of India and not more than 30 judges. So how many judges are there altogether in Supreme Court? Not more than 30. Who is the head? The Chief Justice of India. That is the composition. Okay. Now all of you see in your book. See this. We'll start with the Supreme Court and we'll start with composition. What is their composition? The Supreme Court of India consists of a Chief Justice of India and not more than 30 judges. Till here is the composition. And then you need to understand this. First we have subordinate court, then High Court, then Supreme Court. Okay, but under composition you people need to know this. Now, what are the qualification? You see the qualification. Okay, qualification for appointment as judges of Supreme Court. What is the first qualification? He is a citizen of India. That is number 1. Second, he has been for at least 5 years a judge of High Court or 2 or more such court in succession. This is your second point. Third point, he has been for at least 10 years an advocate of a high court or 2 or more such court. And third qualification, he is, in the opinion of the president, a distinguished jurist. This is third and this is fourth. This is your qualification. Is it clear? Qualification for appointment as judge of Supreme Court. Is it clear? Now, so I have just now done 2 topics of the Supreme Court. What is the first topic? Composition. And composition consists of what? The Supreme Court of India consists of 1 Chief Justice of India and not more than 30 judges. Qualification. What are the qualification? To be a judge of Supreme Court, the person must be a citizen of India. Second, he has been, second qualification, he has been at least 5 years a judge of High Court or 2 or more such court. Then second, he has been at least 10 years an advocate of High Court or 2 or more such court. And fourth one, the person is, in the opinion of President, a distinguished jurist. Is it clear? So these are the qualifications which are required to be the judge of the Supreme Court. Now, how the judges of Supreme Court are appointed? Who appoints the judges of the Supreme Court? Then you need to understand this, that every judge of the Supreme Court is appointed by the President of India. But before appointing the judges as by the President of India, the President does consultation. With whom? With the judges of Supreme Court, of High Court, besides the Council of Ministers. Okay. So if the question comes, who appoints the judges of Supreme Court? Then answer is, every judge of the Supreme Court is appointed by the President of India. It's not complete. Complete will be in consultation with the judges of Supreme Court and of High Court and the Council of Ministers. Okay. Now, if the question comes, who appoints the Chief Justice of India? Then, the Chief Justice of India is also appointed by the President of India. Is it clear? Now, so these are the appointment. Now, underline in the appointment, all of you. See, under appointment, you have to underline, every judge of the Supreme Court is appointed by the President of India in consultation with the judges of Supreme Court and High Court besides the Council of Ministers. This much. This is your complete answer. If the question comes, who appoints the judges of the Supreme Court? Okay. Then, is it clear to all of you? Now, Constitution. Okay, so we have completed the appointment. Now other topics like appointment of ad hoc judges is not in your syllabus. Terms of office is not in your syllabus. Okay, seat of Supreme Court is not in your syllabus. So till now I have done composition, qualification and appointment, which is in your syllabus. Okay, now we'll start in page number 201, independence of judiciary from the control of executive and legislature. This topic we have to study, and we have to study 3 points. First point, appointment of judges. Second point, removal of judges. And third point, security of tenure. These are the, and remaining other points, 4th, 5th, 6th, 7th, 8th, 9th is not in your syllabus. Is it clear? So let me first explain you the 3 points. Is it clear? Now, independence of judiciary from the control of executive and legislature. Okay, I told you there are 3 organs: judiciary, executive and legislature. But judiciary is independent from the control of executive and legislature. How they are independent? Okay, under this we have to study about 3 things. That is the appointment of judges. Okay, I told you that every judge of Supreme Court is appointed by the President after consultation with the cabinet as well as the judges of Supreme Court and High Court. Thus, the judiciary and executive are involved in the appointment of judges. Okay. So yes, because the president appoints the judges of the Supreme Court by consultation with the cabinet, council of ministers. So we cannot say that here the judiciary is independent. No, judiciary is not independent because the president appoint the judges, every judge of Supreme Court, only after doing the consultation with the council of ministers. So we cannot say that the judiciary is independent from executive and legislature, which is not true. Okay, so first point. Then second point, the removal of judges. Okay, judges can be removed. No, judges cannot be removed. In India, till now, none of the judges is removed. But there is one clause where judges can be removed. That is called the process of impeachment. And when the judges can be removed, only when it is proved misbehavior and incapacity. Proved misbehavior and incapacity. When the judges of the Supreme Court is removed. The judges of the Supreme Court is removed by the president only after proved misbehavior and incapacity. Now, what do you mean by proved misbehavior and incapacity? It means that if some allegation is imposed on the judges of the Supreme Court, then it is going to be discussed in the parliament. And when they will discuss, then they will vote. And after the vote, they will set up one committee. And that committee will do the investigation that whether the allegation charged on the judge is correct or not. And if that committee will say that yes, all the allegation is true, then the process of impeachment of the judges of Supreme Court start. Otherwise, the Supreme Court judges cannot be removed until and unless it is proved misbehavior and incapacity. There is a process. Then security of tenure, yes. Like we have studied, the parliament function for Lok Sabha function for 5 years, not for the judges of the Supreme Court. A judge can remain in the office till he has attained the age of 65 years. Before the period of 65 years, he cannot be removed from his office until and unless by the president on the ground of proved misbehavior and incapacity. If the question comes when the judge of the Supreme Court can be removed, the answer is the Supreme Court judge can be removed by the president only in case of, on the ground of proved misbehavior and incapacity. If you write when the judge will violate the constitution, answer is not correct. This is the key word you need to remember. Proved misbehavior and incapacity. Okay, now see all of you in the book and underline the 3 points of the heading independence of judiciary from independence of judiciary from the control of executive and legislature. This you see, the first point, this much. Appointment. In case of appointment, every judge of the Supreme Court is appointed by the president after consultation with the cabinet as well as the judges of Supreme Court and High Court. Thus, the judiciary and executive are involved in the appointment of judges. So, they are not free in the appointment. Second point, removal of judges. Okay. First point is this. The judges cannot be removed from the office by any authority through a normal simple procedure. That is the first point. Second point is this. A judge can be removed by the president only for, this is the main answer, only for proved misbehavior and incapacity. Then third point. This charge need to be proved only by a joint address by both houses of parliament and supported by 2/3 majority of members present and voted. Okay, and the fourth point, the word proved is very important. It means that an address can only be presented after an allegation has been thoroughly examined by some impartial tribunal. So total 4 points are there under the removal of judges, children. Is it clear? And security of the tenure. A judge can remain in office till he has attained the age of 65 years. He can be removed by the president on the ground of proved misbehavior or incapacity. This is the main line, children. Okay, now see. So today I have completed till independence of judiciary from executive and legislature. Tomorrow I am going to start the powers of the Supreme Court. I'm going to, next video I'll complete. I think I'll take 2 more videos, then this chapter will complete. So for today only this much. Thank you, children.